Hello everyone, I'm Gemma and I'm a partner in the employment team here at Ward Hadaway. And today I'm joined by my colleagues Imaan and Chloe, who are both solicitors within the team. So there's been a lot of discussion about the Employment Rights Act and what it means for employers, but unfortunately there's also been a lot of misinformation. So in this Mythbusters edition, we're going to separate fact from fiction by exploring some of the most common assumptions we're hearing in respect to the new rules regarding the reduction in the qualifying period to bring an unfair dismissal claim, which is changing from 2 years to 6 months and expected in January 2027. So jumping straight into it, Chloe, so do the new rules mean we don't need to follow any disciplinary process during those first 6 months?
Thanks, Gemma. That is a myth. One of the biggest misconceptions is that the proposed changes somehow give employers a free pass during this first 6 months of employment. They don't. The proposed change is simply that employees can bring a claim for unfair dismissal after 6 months as opposed to the current 2 years. Even before those 6 months, employers will still need to act reasonably to avoid other claims such as discrimination. They should still have, at a minimum, a reasoned decision-making process, some level of investigation, and always provide the employee with an opportunity to respond. A rushed decision with no investigation will still expose you to legal risk in the same way that it would now.
Thanks, Chloe. Yes, I think it's really important to make that distinction between a simpler process during those 6 months and no process at all. So, moving on, an employee can still bring an unfair dismissal claim if I dismiss them before 6 months. Is that true, Aman?
That is true, Gemma, yes. So, following on from what Chloe's just mentioned, the proposed reforms are not intended to give an employer a free pass to dismiss employees unfairly. The reason for dismissal still matters. Dismissals for discriminatory reasons, so pregnancy, family leave, health and safety activities, whistleblowing, things like that, or other automatically unfair reasons, remain unlawful regardless of an employee's length of service. So having a potentially fair reason for dismissal is still absolutely fundamental to the decision-making process. The usual potentially fair reasons are still conduct, capability or performance, redundancy, breach of a statutory restriction, or some other substantial reason. So employers are still going to need to be able to identify that reason and ensure that it was handled fairly before they process that dismissal.
Thanks, Aman. I think it's also important to bear in mind that dismissing an employee in that very last week before they hit the 6 month threshold, even with a payment in lieu of notice, will not protect you. The 1 week statutory notice extension will be added to their service length, pushing their effective date of termination past the 6 month mark and therefore granting them full protection to claim ordinary unfair dismissal.
Yeah, absolutely.
And so the next myth is the initial period of employment just a probation period? Is that right, Chloe?
Thanks, Gemma. So that is a myth. That's not right. A probation period is a contractual agreement between the employer and the employee. You can have a 3 month probation period, a 12-month probation period, or no probation at all. The initial period of employment, which emerges from the proposed changes, is entirely separate. It's a statutory concept that affects employees' unfair dismissal rights. Your probation period does not determine what employment rights you have. For example, extending a probation to 9 months will not stop the 6 month statutory protection. I think it's employers and managers more generally to avoid assuming that just because someone is on probation that they can be dismissed without following the correct process.
That's right. And on Chloe's last point, I would urge you now to give thought to your probation clauses so to ensure that they don't provide any false sense that dismissals within the probation period are automatically low risk. But that doesn't mean that employers have lost all flexibility, does it, Aman?
That's true again, Gemma, absolutely. So while the reform certainly increased the importance of getting your procedures right, even after the 6 month period, employers are still able to manage performance, address any misconduct issues, and dismiss employees where there's a fair reason for doing so. And in that way, employers still have that flexibility over how they manage their workforce, which is really important for them. What is changing, however, is that managers will need to make decisions about the suitability for a role a lot earlier than they do at the moment. So if those decisions are made post 6 months, a company or a manager, whoever's handling the process, needs to ensure that that appropriate process has been followed. For many organisations, that's going to mean reviewing your contracts, looking at your probation procedures, like Chloe mentioned earlier, looking at policies, and also ensuring that your managers have had that adequate training, making sure that they're prepared before those new rules come into force next year.
Thanks, Imaan. I would definitely agree with you there. So can employers simply ignore these changes until they go live in 2027, Chloe?
So that is definitely a myth. Your current hiring choices now are directly impacted by this change. Staff who you are looking to hire today will hit their 6-month mark just as the law goes live, which means that it's more important than ever to ensure that you really do have those robust recruitment processes in place and that those important probation periods and clauses are properly managed.
Thanks, Chloe. So what's the takeaway here? So we've heard that the Employment Rights Act, it doesn't remove an employer's ability to dismiss employees even after that 6 months, but it does reinforce the importance of making informed decisions backed with evidence and following a fair process. And now is the time to ensure that your contracts and policies are ready for the new regime, particularly any probation periods and disciplinary policies. And if you need any advice on preparing your business for the change, please do get in touch with any of us or any of our employment team, and we would be more than happy to help.